On a Monday night in May of 2026, the Supreme Court issued a single unsigned order, and within hours, two sitting justices were publicly accusing each other in writing of acting in bad faith. That is not how the Supreme Court usually sounds. Justices disagree constantly, but the language in this particular exchange between Justice Ketanji Brown Jackson and Justice Samuel Alito was sharp enough that multiple outlets covering the court described it as a bitter back and forth. Unusual, even by the standards of a court that had already been sharply divided all year. Today we are walking through exactly what that order did, what each justice actually wrote, and the sequence of events that led to it, so you can judge for yourself whether this was the court functioning normally under real-time pressure or something else. Before we get into the details, if you want the actual record rather than a summary of the summary, hit subscribe, because I track Supreme Court emergency orders like this one as they happen, not weeks later. Let me know in the comments, once you have heard the full sequence, whether you think the timing pressure here justified what happened, because I think this is a case where the underlying facts genuinely support more than one reasonable read, and I want to hear where you land. Let's start with the case that set all of this in motion. On April 29th, 2026, the Supreme Court decided Louisiana versus Callais, ruling 6-3 that Louisiana's congressional map, which included a second-majority black district, was an unconstitutional racial gerrymander. Justice Alito wrote the majority opinion, joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett, holding that compliance with the Voting Rights Act did not require Louisiana to use race as the basis for its redistricting, and that no compelling state interest justified the map the legislature had drawn. Justice Thomas also filed a separate concurrence, joined by Justice Gorsuch, going further than the majority opinion in some respects. Justice Kagan wrote the dissent, joined by Justices Sotomayor and Jackson, describing the ruling as eviscerating Section 2 of the Voting Rights Act and rendering it, in her words, all but dead letter, arguing that proving intentional racial discrimination in a state's map-drawing process would now be, in her phrase, well-nigh impossible. She called the decision the latest chapter in what she described as the majority's now completed demolition of that law. That ruling itself is a significant story on its own, addressing a legal question that has been building since the court's earlier decisions in this same general area, and it is worth understanding on its own terms, but the part that produced the sharp public exchange between justices actually came less than a week later, in a separate, much shorter order. Here is the timing problem the ruling created, and it is worth walking through step by step, because the dates matter enormously to what happened next. Louisiana's congressional primary elections were scheduled for May 16, 2026. Under state and federal timelines for military and overseas voters, the state had already mailed ballots to those voters back on April 1st. It had mailed ballots to other qualified absentee voters on April 26th. By April 29th, the date the Supreme Court actually released its decision striking down the map, some Louisiana voters had already filled out and mailed back their ballots under the very map the court had just ruled unconstitutional, meaning votes were already being cast, counted, and locked in under a map the nation's highest court had simultaneously declared invalid. That is the specific, concrete fact Justice Jackson would return to repeatedly in her dissent days later, and it is genuinely a difficult timeline for any court to navigate cleanly, regardless of which direction it ultimately chooses to rule. After the Callais ruling came down, Louisiana asked the Supreme Court to immediately finalize its judgment, essentially asking the court to skip the normal waiting period before a ruling formally takes effect, so the state could begin drawing a new map in time to actually use it for the 2026 elections. The plaintiffs in the case, a group of black voters known as the Robinson plaintiffs, opposed that request. They argued they should have the ordinary opportunity to petition for rehearing before the ruling became final, and they pointed to the fact that the state's own primary was already underway, with some ballots already returned, as reason enough to let the normal process play out rather than rushing. They also invoked what is commonly called the Purcell principle, the idea that federal courts generally should not disrupt a state's election rules or maps close to an election, and especially not once voters have already begun voting, a principle the Supreme Court itself has cited approvingly in several prior cases involving last-minute changes to voting procedures. On the night of May 4, 2026, the Supreme Court granted Louisiana's request in a brief, unsigned order, allowing its ruling to take immediate effect and clearing the way for the state to redraw its map before the midterms. Here is the detail that surprised a number of people who had been following the case closely. Justice Jackson was the only justice who publicly dissented from that specific order. Justices Sotomayor and Kagan, who had both joined her dissent on the underlying Callais ruling just days earlier, did not join her dissent on this particular procedural question about timing. That means the order to fast-track implementation was not a repeat of the same 6-3 split from the merits ruling. It was, by every account of the public record, 8 justices in favor of the fast-track request, with Jackson dissenting alone. Now, let's get into what Jackson actually wrote, because her dissent ran 4 pages and did not hold back. She wrote that the court's decision, in her words, has spawned chaos in the state of Louisiana, and she walked through the same ballot timeline we just covered, voters mailing back ballots under a map the court had already found unconstitutional. She argued that developments following the ruling have, in her words, a strong political undercurrent, and that the state's rush to redraw its map was unfolding in the midst of an ongoing election, against a backdrop she described as a pitched redistricting battle playing out among state governments across the country that year. She wrote that the majority's decision was tantamount to an approval of Louisiana's rush to pause the ongoing election in order to pass a new map, and that the court, having already decided the underlying legal question, was now, in her words, not content to have decided the law. It now takes steps to influence its implementation. She characterized the majority's intervention as diving into the fray in a way she called unwarranted and unwise, and she specifically noted that the question of whether the Callais ruling should affect the map used in an already ongoing primary raised, in her words, a host of legal and political questions entirely independent of the underlying issue the court had actually decided in Callais itself. Justice Alito's response was unusually direct for this kind of order. He wrote that the dissent in this suit levels charges that cannot go unanswered, a phrase that itself signals just how personally each side was taking the disagreement, since justices typically respond to a colleague's dissent, if at all, with far more measured indirect language. Alito argued that Jackson's position would functionally require the 2026 congressional elections in Louisiana to be held under a map the court had already ruled unconstitutional, which he framed as the more troubling outcome between the two available options. He also pointed out that the Robinson plaintiffs, despite raising the possibility of seeking rehearing, had not actually stated an intention to file that petition, and he emphasized that early voting in the primary had already begun by the time the court acted, which he argued only heightened the need for a prompt, clear answer rather than continued uncertainty hanging over an active election. According to reporting on the order, other justices in the majority, including Thomas and Gorsuch, also wrote separately responding to Jackson's dissent, adding to the sense that this was not a routine, quiet procedural order, but one where multiple members of the court felt compelled to put their reasoning on the public record, rather than simply joining the unsigned order silently. Let's be precise about what this order did and did not do, because that distinction matters if you want to actually understand the stakes. The order itself did not revisit or reconsider the underlying holding in Callais that Louisiana's map was unconstitutional. Both Jackson and the majority agreed on that underlying legal conclusion, since Jackson herself had joined Kagan's dissent on the merits, meaning she disagreed with the outcome of Callais but was not disputing it in this later fight. The disagreement in this specific order was narrower and more procedural, whether the court should let its own ruling take effect immediately, mid-election cycle, with ballots already circulating, or whether it should have followed its more typical, slower path of waiting for the normal post-decision process, including a chance for the losing side to seek rehearing, to play out first. That is a genuinely different question than whether the underlying map was constitutional, and it is worth keeping those two questions separate in your own head as you form a view, because collapsing them together is exactly how this story tends to get oversimplified in shorter coverage. Step back and look at what this sequence actually shows. A closely watched voting rights case produced a 6-3 substantive ruling along predictable ideological lines, the kind of split that has become familiar on this court in cases involving race and redistricting. Days later, a much narrower procedural question about timing produced a completely different lineup, 8 justices in one direction and a single dissenting voice, with 2 justices who had just been allies on the underlying legal question splitting off from that same colleague on a question of process rather than substance. Whether you read Jackson's dissent as a principled warning about the appearance of partiality during an active election, or you read the majority's response as a reasonable effort to avoid prolonged uncertainty once the underlying legal question had already been settled, the actual sequence of events, the ballot timeline, the exact vote breakdown, and the language both sides used is now in front of you to weigh for yourself, rather than filtered through a headline calling it one thing or the other. If walking through the actual order, the actual dissent, and the actual response helped you form your own view rather than adopting somebody else's framing of it, hit that like button so more people see the real sequence instead of a summary of a summary. Subscribe if you want more of these breakdowns as emergency orders like this keep coming through the court this election cycle, and there will be more. Drop a comment telling me whether you think this was the court handling a genuine time crunch responsibly, or whether Jackson's concern about appearing partisan in the middle of an active election was the more serious issue here, because I think this is exactly the kind of case where reasonable people are going to land in different places once they actually have the facts.